The Law of Self-Defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey folks, welcome to our ongoing coverage of the Minnesota murder trial of Derek Chauvin over the in-custody death of George Floyd. I am Attorney Andrew Branca for Law of Self-Defense, providing guest commentary and analysis of this trial for Legal Insurrection. A personal message. I know thousands of you are new to me and my firm, Law of Self-Defense, and I have to say it's really humbling to see this onrush of attention, and thanks to so many of you for your kind words and encouragement. For those who'd like to know more about what we do, I'd like to offer each of you a complimentary copy of our best-selling book, The Law of Self-Defense Principles. It's a plain English explanation of use of force law, our area of expertise, and it's free. Normally, the book's $25 plus shipping and handling, but if you'll just cover the shipping and handling cost of getting the book to you, we'll cover the $25. If you're interested, and I hope you are, just point your browser to lawofselfdefense.com/free book. Okay, first, our overview of the day. Today, the state presented three medical or science experts. The first was Dr. Martin Tobin, a physician in pulmonary and critical care medicine out of Chicago. He was presented as an expert witness on respiratory matters. He was followed by Daniel Eisenschmidt, a forensics toxicologist out of NMS Laboratories, who was involved in drug testing Floyd's blood. And the day closed with Dr. William Smock, an emergency medical physician and self-described police surgeon who discussed excited delirium and some other issues. Okay, folks, I won't bury the lead. Today's trial proceedings looked a lot more typical for a prosecution presenting its case in chief than has been the case so far in Minnesota v. Chauvin. What I mean by that is that the state finally had a day in which its own witnesses did not end up doing the defense more good than themselves. We've grown so accustomed to defense counsel Nelson simply having his way with prosecution witnesses that today might appear as if we're bad for the defense. It would be more accurate to say it was not a great day for the defense, which is quite a change from past experience. In truth, however, this is what every day of the trial should have looked like so far. Right now, it is the prosecution in charge, presenting their case, in control of direct questioning. The defense is very limited in what they can do on cross-examination. They can't simply produce their own evidence for the jury. They can't argue with the state's witnesses. They are limited in their cross-examination to only the issues the state has chosen to raise in their direct questioning. These are all real and substantive constraints on the defense while the prosecution is presenting their case in chief. The amazing thing about this trial to date is how well the defense has been doing even while bound by these constraints. Today was, again, far more typical of what should be expected at this point. The prosecution is putting forth its witnesses, framing the issues the way they want them framed, asking the scope of questions the way they want them scoped. Every day should make the prosecution look just awesome right now. The turnaround on that perception really ought not be expected until the defense has their turn at bat, gets to present their own witnesses, to frame the issues the way they want them framed, to ask the scope of questions the way the defense wants them scoped, and then the state finds itself bound by all the constraints that so far have limited only the defense. This is also why I urge all of you to not make day-to-day judgments about how the trial is going, at least not in the sense of expecting any day's events to predict the likely outcome of the trial. A football game is not decided in the first half, and a criminal prosecution ought not be expected to be a wrap when only the state's version of the narrative has been fleshed out in court. That said, the state got done what it needed to get done today with its expert witnesses who unambiguously told the jury that Floyd's death was a direct result of the police restraint used to hold him for EMS, period, and that nothing else mattered. Not Floyd's fentanyl level, not Floyd's substantial comorbidities, not Floyd's poorly made decision to fight for police officers against lawful arrest. So, as would normally be expected at this point in the trial, but has largely gone missing up to now, the state had a good day today. Now, that's not to say the defense did poorly within the constraints I've already described. I will, however, note that defense counsel Eric Nelson definitely appeared tired today. He was hoarse. He was clearing his throat, a bit like I sound right now. Could he be wearing down? Well, who knows? Again, it's only him on the defense in the courtroom against a revolving team of 4 prosecutors sharing the load for the state. Now, with any luck, tomorrow, Friday, April 9th, will be an early day for court, and Nelson will have the weekend to get some R&R, and I trust he'll be back in form on Monday. Now, it must be said that getting handed new state exhibits at night, as occurred to him just last night, after being in court all day, and knowing that review of those exhibits will be necessary for effective cross-examination of witnesses today, certainly can't be making his job any easier. With that noted, let's talk about the first witness of the day, Dr. Martin Tobin, a physician in pulmonary and critical care medicine out of Chicago. A couple of interesting points about Dr. Tobin up front. First, although he normally charges substantial fees, $500 an hour, for providing or for acting as an expert witness in court, he agreed to provide his services in this case for free. His explanation is that he's never been an expert witness in a criminal trial before, so he didn't want to charge. I suppose that could be why. Alternatively, I suppose it's possible he's motivated to do the job for free for political reasons. Who knows? Second, while Prosecutor Blackwell was walking Dr. Tobin through his background, training, education, expertise, and all the other stuff you do to qualify your expert in front of a jury, Dr. Tobin mentioned that a chunk of his practice consists of treating patients who require mechanical ventilation due to a variety of underlying causes, including drug overdose. No kidding. Third, Tobin would arrive at his expert opinion after watching videos of the event literally, he said this, hundreds of times, as well as after leisurely reviewing perhaps thousands of pages of investigative reports, forensic results, medical history, and more. None of that, of course, was available to the officers on the scene as they fought an intoxicated 6'6", 230-pound Floyd as he violently resisted lawful arrest in the presence of a hostile and threatening crowd as they waited for the Code 3 lights and sirens requested paramedics to finally arrive on scene. In any case, Tobin gave Prosecutor Blackwell on direct questioning exactly what the state needed from him, and that was an expert opinion to a reasonable degree of professional certainty that what killed Floyd was impaired breathing that resulted in sufficiently low oxygen levels to cause his death as a result of the manner in which he was constrained by Chauvin and the other officers. In fact, I've embedded a little video clip of just those statements kind of spliced together for your viewing pleasure in the text version of today's content. So there we have it. According to the opinion of the state's retained expert witness, it was Chauvin et al. Who killed Floyd, exactly as the state's expert witness is supposed to do for the state. Surprise, surprise. Blackwell stepped Tobin through more than 2 hours of direct questioning, during which Tobin provided a lengthy rationale for how he'd reached his opinion. And frankly, the entire rationale struck me as working back from a conclusion. That is, it appeared to me that Tobin started with the conclusion that the officer's conduct had killed Floyd, and then worked backwards from there to build out a framework that led him right back to where he'd started. Of course, circumstances were quite different for the officers actually dealing with Floyd, who didn't have the ability to see into the future and know that Floyd would die that day, nor did they know a great many other relevant facts made available to Tobin, but unknown to the officers attempting to first lawfully arrest Floyd and second, get him apparently badly needed medical care. In addition, Tobin's path to reach his opinion involved a substantial amount of high-level medical expertise, complex biological and physical models, even mathematics of a degree that the notation was indecipherable to this small-town lawyer. How any of this stuff would be actionable by police officers called to a crime scene and compelled to fight a large and violently resisting and intoxicated suspect was not explained. Tobin also demonstrated an amazing ability, or at least claimed an amazing ability, to make precise biological determinations from cell phone and body camera video. For example, Tobin claimed to be able to tell the precise instant when Floyd suffered brain damage as a result of low oxygen levels. It was when Floyd abruptly kicked out a leg, all from video. Tobin said he could discern precisely what was happening within Floyd's body, despite there being no physical manifestation of those processes, either while Floyd was alive or upon medical examination after Floyd had died. Indeed, he claimed to discern the exact moment that Floyd died by the expression on Floyd's face, saying 1 second he's alive, 1 second he's no longer. Tobin had models illustrating losses in lung function to the individual percent of lost lung function, although he had no personal knowledge of Floyd's respiratory capacity when Floyd was alive. When asked by Blackwell whether it was true that if someone could speak, it meant they could breathe, Tobin announced that this was a dangerous view, because just because someone was breathing now didn't mean they would be breathing 10 seconds from now. Which, frankly, that answer strikes me as just another way of conceding that the actual statement itself is true. If you're speaking, you're breathing. Nobody has ever claimed that if you're speaking now, it means you'll be breathing later. To undercut the theory that Floyd might have died not from police restraint, but because of fentanyl overdose, Tobin argued that this could not be the case because fentanyl slowed the rate of respiration, and from the video, he had visually measured Floyd's rate of respiration as normal. Unaddressed on direct was the fact that Floyd's respiration was being subject to a wide variety of biological drivers besides fentanyl, including, arguably, the combination of Floyd's COVID history and the prospects for long-term lung dysfunction as a result of COVID, his existing cardiovascular disease, the presence of methamphetamine in his system, his just completed 10-minute physical fight with multiple officers, and more. The bottom line, again, is that Tobin, on direct, delivered what any prosecution should expect their expert witnesses to deliver, the opinion they needed to buttress their narrative of guilt. So, here, embedded in the text version of today's content, is that couple of hours of direct questioning of Dr. Martin Tobin by prosecutor Jerry Blackwell. Now, on cross-examination, Nelson touched on many of the points I've already hit above. Police officers have nowhere near the medical expertise of Tobin. Indeed, they're not even trained to the level of an EMT, much less a prominent physician. Tobin had the luxury of watching the videos hundreds of times, all different angles, still framing, slow motion, and so forth, as well as 7 meetings with prosecutors about the case, including as recently as yesterday and the day before. Tobin had also had the opportunity to prepare for the prosecution a whole series of exhibits, diagrams, illustrations, graphs to use alongside his testimony. Exhibits that were provided to defense counsel Nelson last night. That's not a typo. Nelson got today's exhibits last night. Nelson also emphasized that the biological circumstances around Floyd's death were not a simple model of 4 force factors and limited to the conduct of the officers as simplistically described by Tobin, but in fact were much more complex. Floyd's drug levels, his impaired health, his decision to fight 4 police officers for 10 minutes before they were compelled to restrain him for EMS, all played a role in that day's outcome. Tobin, however, insisted it was all very simple, just one biological process resulting solely from the officer's force upon Floyd was all that mattered, again, exactly what the state had ordered up from their expert witness. On the if you can speak, you can breathe issue, Nelson noted that in Tobin's own report for the prosecution, he'd written that even physicians often believe this to be true. Tobin agreed. You may recall that state witness MPD use of force trainer Lieutenant Mercel had previously testified that he himself taught that concept, that rule. If you can speak, you can breathe when instructing other officers. Nelson pointed out that Tobin's purportedly precise calculations of how many pounds of force Chauvin was placing on Floyd were based on assumptions. You've assumed the weight of Chauvin on May 25th, 2020. Yes, answered Tobin. You've assumed the weight of his equipment. You didn't actually weigh that equipment. Correct, answered Tobin. Body weight force models assumed, the models used by Tobin, assumed that Chauvin kept his weight equally balanced on both legs throughout his restraint of Floyd, but in fact his weight was pretty frequently redistributed. Wasn't it? Nelson asked. That's correct, Tobin answered. The biological models purporting to pin down precisely what happened to Floyd internally as he was restrained by police were based on generalized assumptions for a 46-year-old of similar size, height, and weight as Floyd. Yes, that's correct, said Tobin. A hypothetical person who's healthy. Yes, answered Tobin. But of course we know that Floyd was far from healthy. with severe cardiovascular disease, including a 95% blockage of a coronary artery and severe hypertension, as well as recent COVID. In the real world, Nelson suggested, the specific biology of Floyd came into play. That's correct, answered Tobin. On the issue of fentanyl, Tobin insisted the drug could not have played a role in Floyd's death because he claimed Floyd's respiration was not depressed, as would be the case with fentanyl overdose. Might there be competing factors that could offset fentanyl's respiratory effect, at least transiently? Methamphetamine on board? Adrenaline from a physical fight with police? Tobin downplayed the importance of those factors. Also on the topic of fentanyl, Tobin insisted that fentanyl made people sleepy, even unconscious, when it killed via overdose, and Floyd had, after all, just been fighting police. In response, Nelson brought up the pill fragments found in the squad car, the pills that were found to contain fentanyl and meth, and were covered in Floyd's DNA. If Floyd had consumed the pills in the squad car immediately before being prone on the street, which appears to be the case, wouldn't we expect it to take some 5 minutes before the drugs reached peak effect? Yes, answered Tobin. And continue their effect after that point? Yes, again. This would coincide, of course, with that period of time in which Floyd was visibly slowing down and apparently losing consciousness on the street. With respect to how Tobin had purportedly identified the precise moment at which Floyd had suffered brain damage, the kick of Floyd's leg, Nelson asked if it might be reasonable for a police officer to perceive such movement as continued resistance. The state objected to that question, and the objection was sustained by Judge Cahill, so Tobin didn't have to answer, but the jury heard the question posed, which was, of course, really the point. And that about wrapped up Nelson's cross-examination of Tobin. The video of that is embedded in the text version of today's content. Make no mistake, however, that this cross-examination was nothing like the train wreck the state had experienced with so many of their earlier witnesses, including experts, including MPD officers. Nelson hit important points on cross-examination, but Tobin remained adamant that it was the officer's restraint of Floyd that killed him, period. In short, as already noted, Tobin served the purposes the state intended for him when he was retained as a medical expert for this trial, precisely as he ought to have done for the state that retained him. There was also a brief redirect, recross, and even a redirect of Tobin. None of them really amounted to much, but the video of those is embedded in the text version of today's content as well. So the second witness of today was Daniel Eisenschmidt, a forensic toxicologist with NMS Laboratories. Direct questioning was conducted by prosecutor Aaron Eldridge. Eisenschmidt had been involved in toxicology screening of Floyd's blood, with a particular focus on concentrations of fentanyl and its metabolites, as well as methamphetamine. The purpose of this testimony was to play around with various statistics to encourage the jury to infer that Floyd could not possibly have died of fentanyl overdose. In this context, Eisenschmidt compared the concentrations of fentanyl, metabolite of fentanyl, afentanyl, and methamphetamine to selected populations of other people who had also tested positive for these drugs, with the goal of showing that, hey, look, Floyd's drug levels weren't really all that high after all. As a reminder, Floyd had a concentration of fentanyl in his blood of 11 nanograms per milliliter. I'll just use the number 11 from now on. It's often described, including by me, as a threefold fatal dose of the drug, because for a naive person not normally exposed to fentanyl, 11 nanograms would be 3 times as much as necessary to kill them. It must be said, however, that this fatal dose is presumably for a naive user of fentanyl, and that a chronic user could have a substantially higher tolerance, and indeed would be expected to. Of course, we also have testimony from Floyd's co-addict lady friend earlier in the trial that Floyd had, at least she claimed, been clean for some lengthy period prior to the May 25th, 2020 arrest, right up until shortly before that event when he apparently began using again. Tolerance is lost as well as acquired. So to what extent Floyd had substantial fentanyl tolerance on the day of his death is probably unknowable. In any case, Eisenschmidt would present the jury with a variety of charts, and I'm going to include just 3 of those in the text version of today's content. One of them compared Floyd's blood level to the blood of fentanyl, to the blood level of fentanyl, blood concentration of fentanyl among some 19,815 other people whose blood had been tested by NMS labs and who had died. So these were post-mortem blood tests of some 19,000 people. Those people had an average fentanyl concentration of 16.8 nanograms and a median level of 10 nanograms. Well, look at that. 10 nanograms, that was the median. Now Floyd's concentration of 11 nanograms doesn't look so bad. I mean, look at all those dead people. They had a way higher concentration. The average was 16.8. That's way higher than 11. They had a way higher average concentration of fentanyl than did Floyd. Surely that means Floyd could not have died of fentanyl overdose. Well, one obvious weakness of this argument is it's rather dependent on people not understanding what an average is and what a median is. And that's probably, unfortunately, a pretty safe assumption these days. Now, the median of 10, for example, means that exactly half of the dead people had blood concentrations greater than that amount, but it also means that half of the dead people had blood concentrations lower than that amount, and therefore lower than Floyd's concentration of fentanyl. But that's not even the real problem with this data. Worse, and a point brought up by Nelson on cross-examination, although I'm not sure it got through to the jury, is that these dead people were not necessarily people who died of fentanyl overdose. They were just people who died and then who happened to also test positive for fentanyl. Could they be people who were fentanyl users who had died not from fentanyl, but because they'd been shot? Sure, said Eisenschmidt. Because they'd been in a car accident? Sure. Because they'd had cancer and were taking fentanyl for pain relief until the cancer killed them? Sure. Did Eisenschmidt actually know what any of these people had died from? He did not. Was it possible, Nelson asked, that of the 19,815 people whose positive fentanyl result was included in this graph, fully 19,814 of them had died of gunshot wound? Well, that's unlikely, Eisenschmidt replied, but of course that's not really the point. If the presentation of this data is to suggest that Floyd's 11 nanograms per milliliter was too low to have killed him, this data is in fact entirely useless for that purpose because we're not comparing apple to apples. Fentanyl overdose death, which the defense is arguing, to other fentanyl overdose deaths. A second data presentation, and I'll include this chart in the text version of today's content as well, purported to compare fentanyl concentrations found among people involved in driving while intoxicated on the one hand, and Floyd on the other hand. And here the data representation was really remarkably disingenuous, particularly in the manner in which the data was kind of sorted and organized within the pie. I don't want to do a statistics class in these blog posts, but if you look at the table, you see that about 10% of the people involved in DUI had fentanyl levels comparable to those of Floyd. And these people were alive. I mean, they were driving cars, right, when they got pulled over. Surely that means that Floyd's mere 11 of fentanyl could not have been a fatal dose. Much like the previous chart, however, the presentation of the data here is intended to mislead. Before, we were presented with dead people who tested positive for fentanyl, but we had to dig in before we learned we had no idea whether they died of fentanyl or from some entirely unrelated cause. Here, in this second chart, we are presented with DUI cases, but guess what? We have no idea if any driver's intoxication was the result of fentanyl or some entirely unrelated substance like meth or pot or even just alcohol. So again, we're not comparing apple to apples. There is, of course, a fundamentally different flaw in all of this data presentation, and that is that even if we had apples to compare to apples, all the apples are substantively different, so not even that comparison can really be done. If we had the identical fentanyl dose and gave it to two different people, the physiological response could easily be wildly different depending on their size, their general health, any developed tolerance to fentanyl or other opiates, and other factors. But we never have identical fentanyl doses because there's no control for that in this data. Some of these people were likely taking fentanyl lawfully, prescribed by a physician for lawful purposes, a genuine pharmaceutical. Others were taking genuine pharmaceuticals, prescription drugs, but unlawfully. They were not prescribed to them. At least those two populations have some idea of the dose they're actually ingesting because they're consuming pharmaceutical-grade fentanyl. Most of those people in the data, however, are consuming street fentanyl, or at least many of them are, and there are no good manufacturing practices for street fentanyl. No two pills are the same, even in physical characteristics, much less in their constituent chemistry. When one takes a street fentanyl pill, one is taking an unknown dose of fentanyl, and one likely mixed with some other combination of illicit drugs, methamphetamine being a common pairing, as we saw in this case. The direct questioning of Eisenschmidt then stepped through a similar, what I will say is a faux data representation in the context of methamphetamine instead of fentanyl, but I won't bother dragging you through that here. I will note, however, that it does appear that Floyd's concentration of methamphetamine was rather low. This raises the legitimate question of whether it could have had the offset, the counterbalancing function to counter the sedative effect of fentanyl, as has been occasionally suggested by Nelson. Obviously, the state's witnesses played down that possibility, as we'd expect, so having heard only them, the theory appears tenuous at this point. We won't really have an informed understanding, however, until we hear from the defense medical experts later in the trial. Another issue raised by Prosecutor Eldridge on the direct of Eisenschmidt was the ratio between fentanyl and its metabolite, afentanyl. So when fentanyl is ingested, we get an immediate level spike of fentanyl in the blood within a few minutes, and then over time, that fentanyl is metabolized to afentanyl, which can also be measured. And if we limit our consideration to a single dose, eventually what happens is the levels of fentanyl will drop as the levels of the metabolite, afentanyl, will increase. And we can look at the ratio between those. Now, Floyd had significant levels of both fentanyl and afentanyl in his system. Eldridge argued from this that, hey, look, Floyd must have taken his last dose of fentanyl some time ago, well before interaction with the police, because a bunch of it had already metabolized to afentanyl. Therefore, given that the peak effect of fentanyl normally occurs within 5 minutes of dosing, Floyd could not still have been under the effect of fentanyl when subject to arrest, or at least not a recent dose of fentanyl, because it had already begun to metabolize substantially. If Floyd had only just taken fentanyl moments before, she argued, there would have been no time for the afentanyl to present as at such meaningful levels. There is, of course, an entirely distinct and opposite, really, interpretation of that same data. And it was one pointed out by Nelson on cross-examination. What if we're not talking about someone who just took a single dose of fentanyl, but rather someone who took fentanyl on a habitual basis, like, an opioid drug addict like Floyd? In that case, we'd expect him to take fentanyl dose 1, for example. Fentanyl levels would quickly spike, then begin to drop as levels of the metabolite, afentanyl, increased. And if we left things there, eventually fentanyl would go to 0, and even as afentanyl was continuing to increase. But what if the user then took a second dose of fentanyl? Perhaps while fighting multiple officers in the back of a squad car, spewing partially chewed and spit-covered fentanyl tablets all over the back seat of the vehicle. Then we'd expect to see afentanyl levels present for the metabolized dose of 1, dose number 1, but we'd also expect to see high fentanyl levels present from the just taken dose 2. Nelson pointed out some of these data incongruities and metabolite deceptions in his cross-examination of Eisenschmidt, but I'm pretty sure that Nelson wasn't a statistics major in college, and so it was difficult to substantively and clearly undermine Eisenschmidt's presentation of these data and figures. And even if Nelson had possessed the necessary statistical savvy, the effectiveness of deploying that savvy would also be a function of the ability of the jury to absorb what was being said about statistics. And I expect there maybe wasn't all that much of that ability for much of the jury. Now, if all Eisenschmidt accomplished for the state was to throw some data and charts in front of the jury at the prosecution's request and created the inference that this meant the prosecution's narrative on the role, or no role, of fentanyl in Floyd's death was supported by the science and the math, well, then he accomplished his mission for the state, at least again, until the defense can bring their own medical experts before the jury. So the direct, the cross, and the redirect of Eisenschmidt, the video of all that is embedded in the text version of today's content. Finally, we have Dr. William Smock, emergency medical physician and self-described police surgeon. Direct questioning of him was conducted by prosecutor Jerry Blackwell. Now, frankly, Dr. Smock struck me as a bit of a nut job. I'm going to have to be careful not to call him Dr. Spock. I'm just really realizing that, saying the name aloud for the first time. But in any case, Dr. Smock was portrayed by the state as having a substantive expertise, not just in emergency medicine, but in forensics. In fact, a close reading of his self-stated background and qualifications suggests his expertise is much more akin to that of a hobbyist in forensics than actual formal expertise. Further, he oddly informed the court that he engaged in something I'd never heard of, which is living forensics, which he described as applying the same forensic techniques to living patients as was more routinely applied to corpses. I'm presuming that does not include autopsy. Further, Dr. Smock is not board certified in forensics, has no degree in forensics, and has never been employed to do forensics. Rather, he has what he calls specialized training in forensics. This could simply mean that he has a personal interest in the subject and attends local continuing medical education courses in it. Oh, and he said he subscribes to a forensics science journal, although I note he didn't say he reads it, actually. He just says he gets it. And in any case, like Dr. Tobin, at the start of the day, Smock was present for the explicit purpose of sharing his expert opinion that Floyd's death was the result of hypoxia induced by police restraint of Floyd, period. And he did that. Indeed, he stated outright at the start of direct questioning, Floyd died of positional asphyxia from pressure to his chest, back, and neck, period. Period is mine. He didn't say period. He had, as a second purpose, to share his opinion that excited delirium could not have been a causal factor of Floyd's death, and he spent considerable time during his direct questioning focused on this particular issue of excited delirium. Specifically, he showed a list of 10 characteristics of excited delirium, announced that at least 6 of the 10 must be present for a diagnosis of excited delirium, and then concluded that, in fact, in his opinion, not a single one of the 10 characteristics could be found in Floyd, and thus, as far as he was concerned, excited delirium was off the table. I found Smock's testimony on this point to be really disingenuous, in that he would carefully cherry-pick pieces of Floyd's conduct from different points during the interaction, and Floyd's conduct changed a lot over the course of the interaction, but he would cherry-pick different pieces of conduct until he found what he felt was evidence that was contrary to a diagnosis of excited delirium, and then he would choose the next example of Floyd's conduct from a different point in the Floyd timeline entirely. As a result, his portrayal of Floyd as not suffering from excited delirium was made up of a kind of patchwork of different Floyd characteristics chosen from different points in time. Now, I've included Smock's slide that lists the 10 characteristics of excited delirium in the text version of today's content. Now, I'll note that one of these is constant or near constant physical activity. And Smock concluded this characteristic was off the table, didn't exist in terms of a diagnosis of excited delirium that could have caused Floyd's death, because Smock pointed to the period very late in Floyd's restraint and pointed out, well, he wasn't moving much late in the interaction. Well, of course he wasn't. He was probably dead or about to die. And that period of relative inactivity would be true of every single person who's ever died while experiencing excited delirium. At some point, they died, and once dead, they admittedly engaged in very limited physical activity. Another factor considered by Smock is unexpected, unusual strength, and in this context, Smock claimed that this characteristic was missing because Floyd wasn't merely hurling the officers off him like the Hulk. Of course, it's also true that early in the confrontation, Floyd managed to fight off 4 police officers attempting to place him in a squad car until they gave up the effort as futile. If that's not remarkable strength, I don't know what is. Now, I could go on with these other characteristics of excited delirium, viewed from one perspective by Smock with carefully chosen examples for the jury, but also could be readily viewed from an entirely different perspective, more consistent with excited delirium by a reasonable commentator. But the truth is, it doesn't matter. The legal question on the subject of excited delirium is not whether Floyd's conduct and appearance actually met the clinical criteria for diagnosis as that would be applied by a highly trained and experienced physician with the appropriate background and education, like, Dr. Smock. Rather, the legal question is whether a reasonable police officer could have believed that he might be dealing with a citizen suffering from excited delirium, thus warranting the use of the police-trained response for that condition, which is full body restraint from head to toe until EMS arrives with the ketamine, a powerful sedative for these applications. It's not important for legal purposes whether officers possessing such a belief that excited delirium was occurring are correct. It's only important for legal purposes that the belief, even if mistaken, was reasonably and genuinely held, given the background, training, and experience of a police officer who's not even trained to EMS standards, much less a doctor. Whether a medical doctor making an evaluation with the luxury of repeatedly watching a variety of videos from all different angles, having the full medical history of the suspect, as well as the suspect's autopsy and toxicology results, whether a medical doctor would have come to the same conclusion as the police officer on the scene is entirely irrelevant to whether the officer's conduct was reasonable and lawful. SMOC was also used to attack the defense theory that Floyd's fentanyl concentration might have contributed to his death, and he did so in what I thought was a genuinely ridiculous manner. SMOC recounted why there was one time when Floyd was brought to the hospital after taking 7 or 8 fentanyl pills, and it didn't kill him. Indeed, all they did was watch him for a while and then let him go. Now, I believe SMOC here is referring to the year earlier drug ingestion event by Floyd upon police contact. Based on that experience, SMOC said, the notion that a mere 11 nanograms of fentanyl might have killed him on May 25th, 2020 was ridiculous when 7 or 8 fentanyl pills a year earlier didn't kill him. The flaws in his reasoning are obvious and numerous. First, we have no idea if Floyd had a substantially higher tolerance at the year earlier event than he did on May 25th. Indeed, we have reason to believe his tolerance on May 25th may have been much reduced, based on the testimony of his co-addict lady friend that he had been clean for a lengthy period of time leading up to that date. Tolerance is lost as well as gained. Second, on the year earlier event that he consumed fentanyl, had a bad response, but didn't die, there were a lot of things that he didn't do that day like he did on May 25th, 2020. For one, he didn't fight for police for 10 minutes as they attempted to lawfully load him into a squad car, even as he was apparently munching on who knows how many fentanyl tablets in the process in the back seat of that car. He also wasn't subject to arrest and restraint for 10 minutes or so while the officers waited for the EMS they'd summoned on Code 3 lights and sirens basis. Now, as has always been the case, it's most likely not that any single factor killed Floyd, but that all the factors working in combination killed Floyd. His fentanyl levels, his compromised physiology, yes, his lawful restraint by police, and his poorly made decision to fight 4 officers for a full 10 minutes and more. Nelson did an okay job on cross-examination of SMOC, but SMOC was an experienced expert witness who knew who was paying him $300 an hour. And given that opposing counsel isn't actually allowed to argue with the other side's expert witnesses, there's only so much that Nelson or any defense lawyer is able to do on cross-examination. Again, the real counterpunch from the defense can't realistically be expected until the defense presents its own case in chief and calls its own medical experts on direct. We've simply been spoiled in this trial with how skillfully Nelson has been able to routinely turn the state's expert witnesses against them. That is not the norm and ought not be expected. In any case, the direct, cross, and redirect of SMOC is embedded in the text version of today's content. The bottom line, again, the state finally had a non-implosive day at trial, which is just another way of saying that today was the normal kind of day one should expect with the prosecution presenting their case in chief. It's supposed to look good for them right now. That's how it works. The state's narrative is supposed to take its hits not during their own case in chief, but only after the defense gets their turn to go on the offensive. Okay, folks, before I close out for the evening, I feel obliged to let you all know that I will not be covering the trial tomorrow, as I have been doing since jury selection for some weeks now. I'm afraid I have other prearranged obligations to attend to. I will therefore leave you in the good hands of Professor Jacobson at Legal Insurrection and the wonderful contributors and staff over there. But don't worry, I expect to be back on the case by Monday. Until then, I'm Attorney Andrew Branca for Law Self Defense, providing guest commentary and analysis for Legal Insurrection. Stay safe.